Hi, Niyati. Very happy to have you on our podcast series and introducing the second phase of our arbitration podcast series. We're very happy to welcome you on board. We're aware of the significant contributions that you've made to both legal academia in public international law and in arbitration related matters. And knowing that you've been a visiting professor at NLSIU and NMIMS School of Law, and also knowing that you've made partner at Shardul Amarchand Mangaldas, one of the leading law firms in India. We're very happy to pick your thoughts and your perspectives on international arbitration and dispute resolution related matters, and we're very happy to have you on board here.
Thank you. Very nice to be here.
Nirti, I mean, thank you for again taking the time out. And just before we, delve into this conversation further, just want to understand that was it always law for you, or it just came about now that you're like, 12, 13 years into what you're doing? Like, when you look back at what you thought you would be, is this something that you thought that you would be doing about 14 years down the line?
So, yes and no. Um, if the assessment is 14, 15 years, then I'm exactly where I plan to be. If the assessment is 20 years, I mean, I would have much rather been Nidhi Razdan. Um, I really wanted to be a newsreader. I really wanted to have my own news show. That was the original dream. And then I was told that no, your voice is too irritating to be a newsreader. So I said, okay, that seems to be like good feedback. Maybe I should apply myself elsewhere. And then I think once law happened, I just feel like even in hindsight, I was just a fit. Not necessarily, in all the old ways that people say, but not necessarily because people say, oh, you're so argumentative, you should be an advocate. But I just like to speed read. I like to write a lot. I take pride in how I present my sentences. Um, Ultimately, that's the nature of the advocacy I find myself doing as well. At no point in time, at least for me, did I feel like I was in the wrong career. Uh, I think maybe there was a couple of months in the middle where I was just like, oh, what am I doing with my life? But I think once I came to terms with that, I was always very happy with it. But I did do one thing to make sure that I felt happy with my choices over time, which is I consistently and constantly revisited the idea. I always kept asking myself if law is the career I want. I always took interest in other careers. If I met somebody, I always asked them, what do you do? What's your life like? Where do you see yourself going? If I met older folks, I would ask them, oh, do you like what you do? Do you see someone my age doing this as well? That I think kept me interested, because I also kept assessing myself from another lens. I always said, oh, do you really think that you'll be able to survive as a consultant? Probably not. Do you think you'll survive in media? Probably not. Are you going to be happy being a soccer mom at home? No. So I have considered constantly everything else I could be, and it always brought me more joy to say that, oh, I can come into my office and do legal things. And that's why I stayed.
I mean, that's also interesting, primarily because of the reason that I think the nature of your job, right? I mean, the more you talk to people about things other than law, I think, uh, I mean, leaving aside the idea of development or whatever, I think just having a genuine interest in understanding about what people do, I think genuinely solves half the problems, or you get to know people better for you to for them or you to feel comfortable to even pursue a next strict like segment of conversation in work or otherwise, I believe. But like that's, I mean, see, that's great. I mean, we all question ourselves in like certain periods, jobs, past jobs, and whatnot. But having said that, uh, for me at least, like I don't know, like when we come into office, like uh, on a given day, to be able to do, what we are, doing on a regular basis, I think that there's a lot to be grateful about, right? There doesn't
Absolutely.
not a lot of people who seemingly get the opportunity as well to do what probably they want to do. So I think that's a great thing. But your journey in terms of, I mean, just a fun fact. I mean, like being in this, so a lot of people might not know, calling yourself an international disputes lawyer in India might be a skewed concept, right? Like, because the whole concept of international disputes predominantly, or, and I might be wrong in saying that, because we do a wide range of work from international disputes to corporate work and you know M&A and so on and so forth, right? But like in big firms like yours, is it is it is it okay to say that when you call yourself an international disputes team as such, there might be positions that, yeah, there are international disputes work, but like a gamut of work also might not be related to international disputes, but it might be related to general domestic arbitration and so on and so forth. So, right?
So I would think that and our team is quite big. We are 20 people, which includes 6 partners. Um, I would say that in the 6 years that I've been a part of this team, we have done exclusively what I would say is international disputes, but perhaps because I give it a broad definition. Of course, I think
Yeah.
I can think of at least one case we are doing, which is purely domestic, which is a construction
Mhm.
related arbitration. But when I say international disputes, I do it like the Arbitration Act does it, which is that at least one of the parties is foreign. I don't necessarily mean that it has to be a foreign forum. It should absolutely be an Indian forum. Okay. Now you are on another network, which I hope will be more stable.
Yeah, yeah.
Okay. So I was saying that we do exclusively international disputes work. When I say international disputes, I typically mean disputes, litigations, arbitrations, disputes just in correspondence. But these disputes still involve at least one foreign party. And we then do the entire range of it. Like we will do institutional arbitration seated abroad. I have also done full-fledged litigations in multiple foreign courts where we take assistance from local lawyers. We would do enforcement, setting aside in foreign jurisdictions. We will incorporate litigating in foreign jurisdictions as part of strategy advice to client, like, for example, getting a worldwide freezing order in a friendly jurisdiction. We will do cross-border asset tracing to help clients determine what is the right jurisdiction for them to um, pursue proceedings in. We will project manage disputes that span across multiple countries, so long as they ultimately pertain to one single dispute between two large corporate groups. Um, we do investor state arbitrations, advisory towards investor state arbitrations, actually acting in investor state arbitrations. Um, yeah, it should be the entire gamut.
Do you find while dealing with these international commercial disputes, uh, especially when they come India side? So there are sometimes when Indians go abroad and sue, but usually sometimes foreigners suing in India. Do you find it difficult to meet their expectations as to how efficient they think a judicial system should be, with given the status of the Indian courts, or are you constantly having to apologize for the ground realities? of Indian court systems?
Hmm. So I think I would answer this a bit differently. Again, I would say that our practice area is almost entirely. I would say a majority of the work we do is for the foreign clients against Indians. There is a small majority, I mean, not majority, a small part of the work that we do for Indians against foreign clients. But typically, it's the other way around. Because of that, at SAM, we consider client management to be a key skill. So it's not just your technical excellence is not simply about how good a lawyer you are. Your technical excellence is also about how you provide services and how your services are received by your foreign client. This therefore means that we really polish our presentation of our circumstances in a certain way. We set expectations correctly. So most clients will not come to us in the middle of an existing dispute. If they do, I mean, that also happens. But if we are going to take over, the first step typically is a proper written strategic advisory memo where we are assessing really where you are, what it is that your objective is, what is the current, what is the best mechanism available to you to reach the goal that you want to. Um, in doing so, I must admit that we very regularly now say that please stay away from Indian courts as much as you can, which is what I meant by project managing global litigations, because we will tell the client that, hey, if you can establish jurisdiction in London, New York, Singapore, do it. Get a worldwide freezing order, get the assets frozen, then pursue whatever it is that you want to pursue in India. Um, so, to answer your question directly, Ajay, we don't apologize for the state of Indian courts. We just accept it. And we say, hey, this is what is going to happen if you come to an Indian court. You might be the 5% that might succeed. But even to be a part of the 5% that will succeed, it's going to cost you $500,000 and 5 years of your life. Is it something that you really want? If it is what they want, we'll go ahead and do it. But upfront, we'll tell them, hey, it's a really bad idea. Don't do it.
So it leads me to my other question that I had. Recently, we saw the government come out saying that they no longer prefer arbitration as a mechanism to resolve their disputes. So, if Indian lawyers are advising avoid Indian courts and the government of India is saying avoid arbitration, how does this translate into ease of doing business from an access to justice perspective? Because the Indian government seems to, as in they're considering amendments, but at least they seem to want to consider move away from the arbitration path. And from what you just explained, the only way for a foreigner to get some semblance of justice is to avoid the court system altogether. So how does this play with each other in terms of policy going forward? Like, do you think India is clear that whether it wants to fix the court or fix arbitration, or are we doing neither as a country?
I mean, it seems like they're doing neither at this stage.
Pretty much.
There were a few years.
No, in my I've had a conversation in relation to this development with several people, and I think it is something that has come about unchecked. And I don't think this will be implemented at large, and there will be checks and balances in place. That's my 2 cents. If you look at the notification which came out, also it was very poorly drafted. There was hardly any, anything. It was just put out for the sake of being put out as an advice. I don't know what you feel, Niyati.
So, see, honestly, I have to tell you that I saw it pretty early on. And before I had engaged in conversation with anyone about it, my first instinct was this is going to be rubbished away. I did not think when I saw it that anybody can be serious about it, right? Um, that said, never say never with the Indian government. Ultimately, we are one of those countries that have issued so many termination notices on BITs when no one else has. So it could happen. It could happen. Absolutely. But Ajay, I think yes, some courts are broken, but some courts work really well. I would say that the Delhi High Court is just absolutely outstanding. Um, I would perhaps also say that about a few commercial courts in tier one and tier two cities, that they're absolutely outstanding. It is possible to get relief in a commercial court in Tamil Nadu. It is possible to get relief in a commercial court in Telangana. It is possible to get relief in the commercial courts in Bangalore. I don't think it's possible to get any relief in Bombay High Court, unfortunately. But I think there are broken courts. There are courts that need assistance that we are not accustomed to giving. But it really is something that we need to see as lawyers as a part of our skill set. Just like we are able to say that, hey, I can get you relief in a Singapore seated SIAC arbitration. I think lawyers like you and me, I do it already. I would say that you should do it as well. I do tell my clients that I'm very willing to go to a commercial court in Bhopal. I will get you an order. Um, and I don't think enough of us are doing it.
Ajay has been very steadfast in that. Has been taking up very high stake litigations, but still in like very obscure parts of West Bengal and so on and so forth. So yeah, we think that until unless you give whoever the client is, until you're able to well-roundedly service them in the remotest of jurisdictions as well. Until that point, I think it's not really client satisfaction, and managing the litigation is one of those aspects of doing that
Absolutely. And
right.
I
I
don't
think
think we live in an India where it's fair for us to say that, hey, I only do litigation in original side high courts. I don't think that's the India we are
absolutely,
growing. It's not the India we are developing.
yeah,
And I
yeah,
just hope that more of us are open to practicing anywhere that needs us.
yeah.
Ajay,
Commercial
you're still
court.
on mute.
Yeah, can you hear me?
Yeah.
Yeah, coming back to the concept which rightly pointed out, right? Like commercial courts in India are becoming quite efficient. And this is because largely in line with the procedure, right? They follow a different procedure from an ordinary dispute. It's a far more expedited procedure. If I'm not incorrect, I think they lifted the rules straight from the rules of the High Court of England and Wales, and they copy pasted them into our Commercial Courts Act. And there are some differences, but they're not too many. But that leads us to the next issue, right, of arbitrations that are seated in India outside an institutional framework. They follow this ad hoc procedure, which tends to mirror the Civil Procedure Code, CPC style ad hoc arbitrations. And these are the ones that are most common because most arbitration clauses in India don't contain an institutional rules set of rules inbuilt, right? In terms of policy going forward, does it make sense for us to actually have a uniform set of rules for these ad hoc arbitrations? Or should we continue to leave it up to the judge's discretion as to how much they want to adhere to the CPC?
So Ajay, I'm a massive fan of the White Book, which are the practice directions that are available in to practice as an advocate in England and Wales. It is excruciatingly detailed. Every scenario you could possibly contemplate is covered. And it really helps to have that much guidance, right? I, however, don't expect much from our bar. I don't think we will come up or agree. Even if we come up with them, I don't think we are going to be able to agree to one set of practice directions. We'll ultimately end up fighting over them all the time. See, what I feel is that the CPC is a great procedural toolkit. The CPC is not the problem. The problem is the lack of transcription. The problem is the arbitrator's lack of control over the proceedings. The problem is the way compensation is designed for arbitrators. There are systemic issues. The CPC is not the problem.
To this, coming to the systemic issues, and this is one question I've been meaning to ask someone who's in this arbitration space for a while, right? In 2015, they amended the act and they brought a whole list of things that could justifiably influence or doubt the impartiality of the arbitrator, right? So, which brings me to the question of appointing retired judges as arbitrators. That judge who is just retired would most likely be appointed by a member of the, on the suggestion of a member of the bar, uh, who would have probably practiced in front of that judge at some point of time. Right? I have business before courts here, and I know that when it comes to arbitrations, we appoint retired judges of courts before whom we have business. Do you think that there might be a conflict of interest that arises out of that? Basically, because that, like, while there are things that prevent litigants from accessing the bench, the lines between the bench and the bar, and we socialize, we meet each other, and eventually an arbitrator's livelihood depends on the number of arbitrations that arbitrator has. Should there be a cooling off period for retired judges before they can start being appointed as arbitrators, or do you think there's no conflict there? Because I see a conflict. I want to know what your take is.
See, again, I think there are two parts to this. One is why are they being appointed in the first place, retired judges? And the answer to that is very simple. One is that a practitioner presumes that the individual he or she is seeking to appoint has experience in decision making, fairness, procedure, and has great respect for the person, and therefore is choosing that this person be the judge in my cause. The second element of this is strategy, because if I'm a recalcitrant respondent, I don't want the proceedings to end. I will make sure I pick a judge whose track record I have seen. Uh, and I will make sure I pick someone who will never finish my proceedings. He'll just keep them going on and on and on and on. It's just a matter of strategy. The third element of it is conflict, which is in what circumstances should it be permissible? And I think disclosure sufficiently addresses this. I think that the IBA conflict of interest rules that were incorporated in the Arbitration Act are fine because they are telling you that, okay, these red list instances are absolutely impermissible. I presume, Ajay, you're saying that if an advocate has practiced before a judge, it should be an item in the red list. But I don't think that's necessary, right? Because if you read the academic work on this, I think one of the most interesting ones is a thesis published by this gentleman called Sam Luttrell. I think he's now a partner at a major law firm. He says that all of these decisions need to be made on the basis of a real danger test. That is there a real danger that this person is going to be, this person's independence and impartiality is going to be compromised? If not, then we don't have enough skilled actors in the system for the needs of justice to be met. The demand is greater than the supply. If you reduce the supply much further, you're going to be in even more trouble.
So my question, let me rephrase. So there'll be a corollary to it, right? Like if I am a judge and I am a year away from retirement, and my post-retirement plans are to be an arbitrator, would it not influence my behavior towards attorneys and parties who are appearing before me then, knowing very well that these are the people who are going to be handing out assignments to me a year down the line? Which is why I'm coming back to the cooling off period, right? Because these are people who literally leave court and go to the next day. They open their own arbitration chamber, started taking on arbitration matters, and their biggest customers are the attorneys who appeared in front of them. So How do
Yeah,
we
Ajay, but these are the
navigate
last
this?
5 years of their career. If you add a cooling off period, you're just going to be at the end of their careers. These people are leaving the
The problem
judiciary
is
when
we
they're
don't have a
65
retirement
years
age for
old.
arbitrators. Listen, we don't have a hard retirement age for arbitrators. I think you and I both know arbitrators who are arbitrating well into their 80s and touching their 90s who need help with turning the pages because they can't carry those. They
But
can't really
council
hold
should
up their
challenge
files
it,
anymore.
right? Council should challenge the appointment at the right in the right forum at the right time. Council should
In
write
fact,
these
I'm not
letters
going
to
to
the
take
SEAT court, for example.
yeah, I'm not going to take names, but it has happened in a couple of arbitrations that we've been part of, where Supreme Court retired judges have been changed thrice over, and parties have taken, challenged appointment of these judges as arbitrators. But I think this topic, as much as it seems black and white, in my opinion, isn't that black and white. Otherwise, we would not be going back to it time and again, right? Because while the issues that Ajay mentioned still persist, there is also a level of trust and the level of expertise that I think that the judges might bring to the table, which might be, effective. I mean, in fact, Niyati, back when we were colleagues, we have appeared before, judges as well, right? Who have been Supreme Court judges, and you know, uh, there have been good experiences and there have been bad experiences, right? And like and as might be the case with any other arbitrator, as might be the case with the law firm partner as an arbitrator as well, right? Like it I think it's a very relative issue as such. So
Yeah, absolutely. And I just
uh
think all of it is not one size fits all. You make the relevant correspondence, make sure your
exactly,
award is going to be set aside.
exactly, exactly. But tell me something. I mean, for us, it's how we work is completely different, right? Like, uh, 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 there are, obviously, in our profession, time constraints and all of that. But like, what is your how is a day in a work life for you? And like, and what is like, the notion of work life balance, so to say, yeah, in a firm which is as big, or like, where stakes are, predominantly very very high, right? Like, does it in these conversations, does it actually play out, how it should play out?
So can I say, um, I've absolutely been a workaholic. Um, and I don't
That
mean
we
to
know.
say this in a good way. I don't mean to say this in a good way. I mean to say it as a negative trait in myself, where I have made many personal choices subject to my professional requirements. Um, it's some I regret, others I don't. Um, but yeah, I think, as I'm a parent, I'm a wife, I'm a major law firm partner. I am a full person for myself with my hobbies as well. Um, and I think there's no such thing as balance. I came across this very nice, really, really nice interview of Miss Indra Nui in my social media feed in the last few days. And she says there is no such thing as work-life balance, and she's so right. She says I juggle all of these parts of me, and every day something else needs attention. And every moment I decide what it is that needs attention. So, no, I don't think there's work life balance. But I chose to be a parent. I chose to be a law firm partner. I chose to do all of these things when I chose to do all of these things. So then it is my responsibility to make the time for it all.
That's fair, but like, in the context of your team, now that there's a team to manage, there are expectations to manage, how does that play out? And like, and obviously you're a mother, you're a wife, you have a family to take care of, so, and you're a big law partner as well. So in the context of all of this, and all the high stakes, situations that you come about, how does it, how does a day, look like?
So I, for example, would actually start very, very early. I start at 5:30. I don't look at my phone more often than not at 5:30. I have, since the last 1 year, taken up working out. So I will go to the gym. I love it because I don't look at my phone. I meet my gym friends who I have nothing in common with except the gym. So we are just laughing at the playlist and at each other's misery. Um, I then pick up my phone at 7:30 when I'm done with this all. Uh, I will do my first set of emails at 7:30, and I'll get most people started for the day between 7:30 and 8. Most task lists, plan of action, telling people what time to what time I'm going to be busy, what time to what time I can speak, etc. Uh, then again, it becomes mom mode. Get the kids ready for school. If there's show and tell, teach them their lines, uh, drop them to school. And it's only after I drop my kids to school that do I head to the office. Once I'm in the office, I have the first round of meetings, emails, and yeah, and then the day takes me wherever the day wants to take me. So I would say my time is just the morning, and then I give way to my calendar.
And I mean, I'm sure there are incredibly long days and like, and so on and so forth, right?
Yeah, it's just par for the course, right? Like, if you have a filing, you have to pull a late night. If you have to travel for hearings and counsel has asked for an 11 p.m. meeting, it is what it is. That's why I say that after my morning, which is mine, I just give way to my day.
So, Niyati, I have a question for you. You've been in the field for so long, and I'm sure it's not a very straightforward field. It is a very complexing and complicated field, right? So, as a disputes lawyer today, how would you say has your experience been throughout, or rather, what were certain experiences or like complicated matters that you worked on that's molded you into the partner that you are today?
You're asking me to reflect on my entire career. Um, but honestly, Jumana, I always say that I am the luckiest person in the world. I always say that whenever I've needed it, luck has turned in my favor. And I've had multiple opportunities to do once in a lifetime cases in the first 10 years of my career. I have uh, done two investor state arbitrations, including one full trial, three investor state arbitrations with one full trial. I have done multiple enforcements of difficult foreign judgments and foreign awards. I am also very proud about the fact that I'm probably the first lawyer in the country who has an order of an Indian court enforcing a UAE judgment like an Indian judgment. I have advised actively on sanctions implications during the Russia-Ukraine war for Indian and foreign clients, um, and countless other opportunities. That's why I say that I am the luckiest person in the world because I've had several interesting opportunities.
I mean, that's super interesting, that you've just, be able to summarize this in a few words. But I also believe, Niyati, that, since you started out as an associate and now there's a stark difference in what this profession looked like, right? Like there is far more number of lawyers, there is there's obviously the opportunities are more. Okay. And you know I mean, this is something that we were thinking and we were ideating the other day. While, of course, the legacy players like the Sams and the the bigger law firms which are there, I think off late there has been also advent of a lot of boutique law firms, which I would like to believe like us, right? And uh, which there has been a shift in terms of how clients also look at uh, you know uh, how the industry is currently in India, right? Like with these players coming in, right? So what do you think has been, of course, the legacy players are will always be there, and it's irreplaceable to a way because they've shown the path to a great extent. But with the advent of foreign law firms, the conversation regarding foreign law firms coming in and so on and so forth, do you think that these developments of smaller outfits coming up, right, giving more opportunities to people across sectors, because in Bangalore we feel, I don't know about Bombay or Delhi, but in Bangalore we truly feel that uh, there has been a very big shift in terms of how clients look for legal service providers, right? Uh, it, for them here, it's purely and it's very competitive, right? Like at least in the private equity, venture capital, mergers and acquisitions field in Bangalore, it's extremely competitive. Okay. And obviously you will be aware because the people who receive the PE money or the VC money are fairly young people, right? Like they often don't want to go to big outfits and so on and so forth, right? So there's a huge advent of boutique players in this market, right? How has your opinion been towards that, like, and what is it like in Bombay or so on and so forth? Because
See,
we
please go ahead, Anubhav. I didn't mean to interrupt you.
no, I was concluding anyway. Yeah.
Okay, cool. So I actually think that there were two key changes. Um, one on the buy side, one on the sell side. Um, on the sell side, our supply has never been sufficient for the demand for lawyers and legal services. We might have countless lawyers, but we don't have so many great lawyers. And the big change that has happened in the last 15, 17 years has been A, the common law application test and the publicity that it has given to law as a profession. The second has been excellent law schools coming up everywhere. Um, Jindal is a great example. Um, Another great example is the NMIMS School of Law. So many more NLUs. That's the main big one that has come on the supply side. On the buy side, what has happened is India has become the center of the new international economic order. And that means that business has been centered here. Uh, there have been many countries that have come and gone, but somehow in the last 15 years, we've held ground. And I expect that we will continue to hold ground. What this has meant is that the quality of our legal services have had the opportunity and systemic support to grow. Um, SAM can grow and it can keep growing, but it's already a massive organization with very clear business objectives. But every business player in the market doesn't need a SAM. Every business player in the market has to find the right legal services provider for them. And that's really where boutique law firms like yours come in because you will be able to serve a particular sector of clients' needs, which I think is awesome. I feel particularly so about the disputes practice. I feel that it has not yet happened or not yet happened sufficiently. But big law firms are just always conflicted out of good cases. you know. The most fun cases are a conflict. And that's the role for you to play because we don't want them clearly. They need lawyers as good as us. And that's where you come in, really. And I think,
Yeah, I mean, that's what.
I don't know about the foreign law firms. I don't know how they will fare in this entire thing. And the reason I say that is, I mean, it's such an anecdotal thing to say. It's such an experience-based thing to say, and I don't like it when people say things without data supporting it. But I just feel that you can't serve an Indian client without an Indian perspective. I feel Indian economics is
Absolutely.
different. Indian business is different. Indian people are different. Indian culture is different. And your client will just tell you, Madam, aap to samajhte ho na. And
And
they're
it
not
does
going
not,
to say that.
and in this context, it does not matter whether you're a big law firm or a boutique law firm.
Absolutely not at all, right? They just want an Indian face. I used to think at the beginning of my career that I will never be able to offer that comfort to an Indian client because I'm a woman. But that has never, ever been a problem in my career. I have been lucky to practice in an India that looks at me for my talent, not my gender. But I don't think, I don't think an Indian executive in an Indian company is going to share as freely with a foreign lawyer for some time.
Stemming from what we just discussed, another question for you would be how challenging has this profession been for you as a female lawyer? Or like, what is it that you've encountered that's actually built that strength and confidence in you to move in the direction that you're heading towards?
Again, Jumana, this is a comment I'm making again, but I've just been very, very lucky. I have along the way always found mentors who put me forward. First, nobody hesitated to spot my talent. Second, once they knew about it, they put me forward for every cool opportunity that they saw. Um, Even when I have done the most ridiculous things, people have covered up for me and have told me, hey, you belong in this. You have to keep doing it. And the most encouraging aspect of this entire thing has been all the women leaders I have met along the way. Women are everywhere today in leadership positions. They are in charge and they are not going to let anyone mansplain you in a boardroom. Every boardroom I now walk into, if there are less women, somebody, if it's not even me, somebody else will say there aren't enough women in this room. And that bodes so well for what's to come. And can I please say that the women in government leadership positions are the best of them all? Our female public servants are just out of the world. And if anybody tries to mansplain you in front of them, they are just going to say, hey, she was trying to say something and give you your due. So again, if anybody is worried that they're going to be treated differently because they're a woman, they really shouldn't, and most definitely not in international disputes. Again, I go to the smallest courtrooms in the world and I'm treated with the utmost respect. I don't think there's anything to worry about anymore. Sure, we have some way to go, but I don't think the assessment necessarily needs to be our 50% of all of the partners at Sam Women. We are getting there. But I don't think that's the fair assessment. If somebody wants to drop out, they drop out. But I think we now have women in sufficient leadership positions, at least in a place like Bombay, or at least in a practice area like international disputes.
100% of the associates in Triumvir Law are women, so we are we are covered that way.
But this leads to an interesting question, Nidhi. While there are a lot of women in the top law firm management positions, like you rightly pointed out, in cities like Mumbai, etc., why do we find a dearth of them when it comes to the bar? Why are there very few women senior counsel leading these international commercial disputes? And the number of designates every year, no? I end up counting the number of women. Like, it's far easier to count the number of women on the number of on your fingers who get designated. So while it's happening in the firms, it doesn't seem to be happening at the bar. Is there any idea why this is the case?
There are two things again. First of all, the biological clock and the career clock are in complete conflict with each other. Whenever you're ready to be successful, your children, you need to be making children. Whenever you're ready to go to the next level, your children need you. By the time you're ready to go to the next level, your parents need you. Um, there's a complete conflict. And there is also a systemic issue with women being presumed to be the caregivers in every instance. There isn't enough support for us. There are not enough services that help us care for our ailing parents. There are no daycare centers anywhere. Where do I leave my kids? Who's going to look after them? Would you rather that I not have kids at all? Is that going to be great for the economy if we don't have the next generation? No, absolutely not. Nor are men willing to be flexible and staying at home, nor are workplaces making space for men to do that. And being at the bar is the most testing, taxing profession in the whole world. Can you imagine being in court on your feet, 9:30 to 5:30, going home for 1 hour, starting again, reading your briefs for the day, and being ready for the next morning? It just is in complete conflict with all other aspects of your life. So unless the world is ready to give us equal support in the home, if the government is subsidizing childcare, it's not going to get better.
As
But
that
at some level, it big question of childcare, right? Our workplaces are now above a certain number required to have a crash in place. I know the Bombay High Court opened a crash for practicing advocates at the Bombay High Court. Do we need, when you mean like a daycare solution and taking on the domestic responsibilities, right, shifting between men and women, is this something that we need to do from an infrastructural level or policy intervention, or do we need to actually talk to young lady advocates just about as they're leaving the bar and have exit interviews and actually find out why they're leaving?
It's all of
Do
the
you think
above,
that
yeah,
system might make sense?
Ajay. It's all of the above. A daycare center in court is not enough. You need a daycare center in your neighborhood close to your child's school. Um, you need a mentor, a sponsor who will guide you. In structures like SAM, there's so much mentorship available. Is it available at the bar? Um, it's just not. Um, I just think that women will not make that choice. It's not that the opportunity is being taken away from them. I think it is as much women not choosing to do it.
it is difficult. It indeed is difficult, but I also see that there are changes for the good. I mean, for example, where my wife goes to work, it's a tech park, and that tech park is self-sufficient in terms of preschools, you know, creche, nanny services, and so on and so forth. But like you said, it does not answer the entirety of questions. But like, we can only ideate and move forward, right? I mean, and that's
Absolutely. You
and
just
you
figure
obviously
out where you
serve as an
can.
example. Exactly. And you obviously serve as an example, I mean, in doing that and how to do that. And but the practical difficulties between the of managing a life as a litigating lawyer, as opposed to a law firm partner, I think there are stark differences in you know how that works out. But yeah, but having said that, yeah, Niyati, I mean, if you were, and this is a very Nikhil Kamath type question which he asks everyone. If you were a lawyer today, okay, let's say starting out, okay, would you have done anything differently to be where you are?
I want to say that I would have paid more attention to the person I am along with the amount of work I did. But I don't think it's possible. I don't think it's possible to survive the first 10 years of your career in client servicing without being a workaholic. I just think client services are a tough field to be in. So you just need to work hard enough. I never felt the need of a master's degree either. So if you don't want the debt, I don't think you need it. I don't think I
I think
choose.
one can do that after maybe, I mean, one can do that as a once they are, maybe settled in life and so on and so forth, right? Like if they at all
Absolutely.
want
And
to.
in an international disputes team, we don't give more weight to a CV with an LLM than we do with a CV with an LLB.
Absolutely. Absolutely.
Nor do we give them a year
I,
credit.
I chose to I chose to take a personal break 1 year back because when I thought that I was maybe financially capable, positionally capable to do so, and I did, and it was also a strategic decision for the firm, like for different reasons for the firm, for me to be there in Europe. But I did that. But I truly agree. I think a master's degree adds, on this conversation, it adds no value to you being an international disputes lawyer or a corporate lawyer or so on and so forth. Uh, it is a good experience to have if you are not in debt, or you need a year off, which I needed after founding a firm for 5 years. I needed to get away for some time. But like other than that, I think it does not add much value. Yeah.
The
Speaking
other
of
thing
which,
I think I would have done
really,
differently, guys, is soft skills. I think I didn't pay enough attention early on to um, relationship management within your own team. I think we do focus on soft skills, client facing, but I don't think we train for soft skills inside inside the organization. I do think I could have benefited from that perspective in my career. Like I thought I could have used better soft skills training, and I absolutely could
When
have
you say
used.
within the
A,
team,
yeah,
when you say within the team, what are you referring to as such?
I just think
Like,
the
uh,
respect you should have for your colleagues, the understanding that we are all working towards a common goal. I think also the reason explaining to the group why there is a hierarchy, what is the role each person in the team is playing to make the entire objective work out. Some of this could also be resolved with transparency. I don't think there's enough transparency in the law firm system. People don't really know how the top rung is being compensated, how they are getting there. Uh, and so they don't really understand how it is they will get there. I think younger lawyers get in believing that I will be the technically best lawyer in this group, and that's what's going to take me to the top. And I don't think that's the right perspective.
yeah, I mean, I think to be a well in and again, like to be a well-rounded lawyer, it's just much more than being a good lawyer like in the letters of the law, right? Like there's so much more to it. And in fact, like Jumana is one example. Like we keep telling our associates that uh, you, just doing the work and sending out the work does not end there. It also entails how you speak to the client. It also entails how you delegate, how you manage your time, how you deal with timelines, and a lot more other things. How you deal with your juniors, and so on and so forth. I think uh, that's absolutely correct in what you say. In in addition to how you would have looked at it differently, uh, as an international disputes lawyer in India, and I think I've asked this to everyone who's appeared before, and we've had a couple of European lawyers and ICJ lawyers who appear regularly before the ICJ in our earlier sessions. Do you think that as Indian outfits dealing with international disputes, and when I say international disputes, might I'm tending towards, let's say state dispute, right? Which are extremely niche and once in a decade sort of disputes and so on and so forth, right? And we've seen it ourselves, Niyati, that we tend to appoint in these sort of disputes or high stake investor state disputes also, the client more than anything would want to appoint like a KC uh, for councils. When will we have the capacity to deal with these issues in house? And
So,
just as
Bob,
a follow up of this question,
yeah.
do you think that, because we have faced this in our in our interactions with clients, that when I was in Europe, for example, and when we were pitching to work to different players, and there might have been certain Asian centric disputes or African centric disputes, there is a huge requirement of language, right? Which Indian lawyers might lack, right? For example, a knowledge of French, Arabic, Spanish, and so on and so forth, right? Like, have you faced this before?
Okay, that's also very interesting. I think first, um, we have come in the last 10 years a long way in terms of the assistance we take from foreign lawyers. When I started my career, if there was a foreign seated arbitration, foreign court proceeding, um, instantly, even inside major Indian law firms, we would immediately reach out to foreign law firms, small, large, London firms, Singapore firms, to run the proceedings for our clients. Um, Somewhere in the middle, there was a phase where we started acting for our own clients in these kinds of proceedings, but the quality was just not up to the mark. I would say today, um, great disputes teams in India perform at the same level as great disputes teams overseas. English speaking, I don't know anything about practices in other languages, but I would say my team is as good as a major law firm in the US or the UK. I think you could give a submission prepared by my team to anyone blind, and they would presume it's from a major international law. Uh, and I think if we've gotten there in written advocacy, it's only another 10 years that's going to get us there in oral advocacy, as long as we keep at it. That's one. Second is, I don't know if we necessarily need to think of English as a disadvantage. I think we need to see English as India's biggest advantage. We have so much labor, so much English speaking labor available, skilled labor available, that we can service the whole world. And I think that's the way to look at it. That I think India, and I think India is doing this at a foreign policy level. They need to be the leader of the global south. And they need to say that I know you have 3 people in your organization who speak English. Please use them and let us be your voice. We promise you that we will bring your voice We will not bring Western interpretations of international law. We will not allow international law to operate in the westernized way that it has operated. We will
Yeah,
bring the new international economic order to force. And India
between you and
is doing it, if I can just finish, India is doing it in international policy. But what India has not done is use international law and its skills in international law as a part of this international policy. And I think it's time for that.
I mean, absolutely. And I, for us to be a leader in the global south, and that's what we should be, that's what our mission should be in terms of how we demarcate. And I think we are going towards that, you know, that trajectory itself. But like you mentioned that, for us to see how international law works, we should be creating the new world order for that. But, as we've seen for decades, international law has always been considered as a Western construct at best, right? Like, um, the representation from Asian countries or the contribution from Asian countries, if not minimal, are invisible in my opinion, right? Of course, things are changing. You see the working group three, how they work and what are the contributions, and you know, and if you see the new, obviously, if you like, Justice Greenwood and Justice Bhandari's nomination when the extension period was happening, and where Justice Bhandari, was reinstated as opposed to Justice Greenwood in the ICJ. Of course, we are seeing that change, right? Uh, but then I think that is a longer time period in my assessment than us reaching that level of advocacy uh, in international disputes, then moving the narrative to a more neutral environment as opposed to a Western narrative in entirety.
I think, we are already there. Anubhav, like if I had an investor state arbitration today against
Yeah,
even a mid-sized state or even perhaps a large state, if it was my client, someone in my team would do the advocacy, or we would approach perhaps an Indian counsel. Um, it just requires people like you and me in leadership positions to make those choices because the talent is there. It's the courage to make the choice that has been lacking.
true, true. I think, and I mean, of course, in terms of international disputes, at least, I think wherever India is concerned, I think we are going towards the right direction, and it's only been better. It's just, slowly, we can see the transitions, we can see the changes of how these, changes are playing out, and I see more and more, people working on these sort of issues, more and people. I mean, I see a lot of people, in fact, students going out doing their masters, pursuing jobs outside, and then coming back and adding to the work pool, and I think it's a pretty welcome change. But then, yeah, with that, I think it's been a pleasure to have you, and I think we've touched a lot, not thinking that we've touched a lot. I think we've actually spoken about a lot of the issues that we wanted to speak, and it was a very, very, in my opinion, a very, very free-flowing conversations on, the major issues that we wanted to talk about, how the current legal situation stands, how, what is it for, like, to be a leader like you, wherever you are, so that, a lot of people see this or hear this in whichever platform they want to do so, and, get inspired, right? Right. And also to inspire a next generation of international disputes lawyers, because in India, normally when you see lawyers coming in, you see either going for the generic route of corporate lawyer or a disputes team, to know that there are very specific niche teams which are working towards that, and and with you at the helm, I think that should serve as great examples for, law students coming up to see, and, where what the ceiling truly can be. Thank you, Niyati,
Absolutely.
and
I
we
love the
look
India
forward.
we are living in. And thank you guys for inviting me. I'm sure the next generation will have much better careers than ours. And I'm excited to watch that.
I truly hope so. I truly hope so. I truly hope so.